Good morning, everyone. Welcome to today's hearing. Today we're going to hear closing statements in Module 3 from some of the core participants. And first up, I think, is Ms. Barwise on behalf of what we now call Team 1 of the Bereaved Survivors and Residents. So, Ms. Barwise, if you're ready, would you like to come up to the Council's desk?
Thank you, sir.
Thank you very much.
Good morning, Mr. Chairman, Assistant Van, Mr. Akbor. The evidence in Module 3 has laid bare the sheer extent of failures of both the managerial and physical controls at Grenfell, which ought to have been kept in check by the statutory fire risk assessments under the Regulatory Reform Order, or RRO. A profoundly worrying sense of responsibility for fire safety pervaded the dealings of RBKC and TMO with each other, and in turn TMO's dealings with its fire risk assessor, Mr. Stokes, whom Dr. Lane considers in some respects reckless in his approach to FRAs. The issues highlighted by Grenfell echo beyond it and more broadly across the housing and fire risk assessment sector, and demonstrate the need for adequate focus on safety. RBKC's failure, to scrutinise TMO adequately or at all, created a culture in which TMO felt free to mislead RBKC's Housing and Property Scrutiny Committee by TMO's omissions and tardiness in reporting on fire safety issues such as deficiency notices. An exemplar of the sense of lack of responsibility for safety is the failure of both TMO to advise RBKC and RBKC officers to advise internally of the need to make funding available to TMO for safety critical issues, such as flat entrance doors. Doors are essential to compartmentation, which is essential to life in a fire. Further causes of significant concern are the lack of competence of those involved in installing the gas riser in the stairwell in such a way that it was, in Mr. Hancock's opinion, non-compliant and totally inadequate. Furthermore, the gas riser should not have been installed in the stairwell at all, given that it is a protected shaft as defined by ADB. The gas industry's ignorance of this in 2016 is profoundly troubling and demonstrates the need for better cross-discipline understanding. Residents rightly complained about the installation of the gas riser in the stairwell, but residents having to raise the alarm is an indicator of systemic failure. I should say at once that we've chosen to focus on that which is causative, as we must if we are to learn the lessons of Grenfell and prevent recurrence. Whilst we recognise consultation with residents and effective complaints procedures are also important, we have confidence that the inquiry will address such matters. RBKC has also candidly accepted that the residents were not listened to as much as they should have been. We emphasise, however, that clearly it cannot and should not be in any way incumbent on residents to identify shortcomings in safety, particularly fire safety, which is complex and highly building specific. Obviously, residents should be provided with information and be consulted and have a route by which to express legitimate concerns, but they must not be put in a position where they are required or even expected to police building safety. The scope for consultation on safety-related matters is therefore very limited. The truly causative events within Module 3 appear to us to begin with RBKC's failure to prioritise fire safety, with consequential trickle-down effect to TMO's leadership and executive. This overarching failure led to the other causative failures, which I will now outline. First, RBKC and TMO's decision not to instigate a flat door entrance door inspection programme and lack of effective door closers on many doors. Second, RBKC and TMO's failures of oversight, which resulted in their overdependence on and lack of scrutiny of two of the people with the greatest influence over fire safety, namely Janice Ray as Health and Safety Officer and Carl Stokes as fire risk assessor. This in turn led to Stokes's inaccurate fire risk assessments going unchecked. Critical inaccuracies include failure to take into account the effect of combustible cladding and the presence of vulnerable and disabled people, and the consequential failure of TMO and RBKC to prepare personal emergency evacuation plans. RBKC admits a failure of oversight in relation to the PEEPs. Third, TMO's failure to upgrade lifts to firefighter lifts, which failure resulted in the inability of the lifts to be used as evacuation lifts and led to the inoperability of the key, given that it appears that the wrong key was used on the night, which could never have happened had the lifts been firefighter lifts, in which a distinctive type of key is used. Fourth, failure of the smoke control system, which appears to have facilitated smoke spread both by the nature of its design and installation. Bearing in mind, however, that there are to be further expert reports on this in Module 7, I shall say nothing further about that at this stage. I shall also say nothing further about the failures of the other passive and active measures, which are explained in detail in our submissions. Instead, I shall focus on the themes which give rise to these failures and the fire risk assessments of Carl Stokes. I begin with two overarching points. First, many of the failures, particularly the decision not to implement a door inspection programme, raise the spectre of insufficient funding of social housing, which appears to have led to a defeatist strategy of make do and mend, even if that meant compromising safety. It appears, however, that the lack of funding in the case of Grenfell and RBKC was more imagined than real. According to the submissions of the Department for Levelling Up Housing and Communities, RBKC had available to it sufficient funding to carry out works such as the door inspection programme in the form of 4.4 million right-to-buy receipts, which RBKC had returned voluntarily instead of using them to carry out necessary works. RBKC also had a borrowing headroom of 11.4 million. The inquiry will no doubt wish to explore in Module 6 the extent to which government was aware of such behaviour and the extent to which it may have been motivated by deregulatory policy. A second broad issue to bear in mind when considering Module 3 is the importance of not conflating the statutory regimes which apply to each stage of the building's lifetime, from design and construction through to occupation. Building regulations and the construction design and management regulations apply to the design and period of construction, but once the building is built, then the RRO is the single statutory regime governing fire safety. The RRO needs no other legislation to support it, given that it protects all residents and visitors, including vulnerable and disabled people. It is important to recognise the centrality of the RRO to a building's fire safety, since dilution of its importance results in Stokes's flawed assertion, based on his interpretation of Dame Judith Hackett's review, that risk assessors are peripheral in the hierarchy of those involved in building safety. Stokes's submission is flawed, as the fire risk assessment serves as the foundation for all the fire precautions in the premises, according to one piece of Article 50 guidance, and as is clear as a matter of construction of the RRO, which requires the responsible person to take general fire precautions to ensure the premises are safe. These precautions are necessarily defined by the fire risk assessment. This leads me to one of the key themes in Module 3, namely the question of competency of fire risk assessors. Stokes, relying on the evidence of one of the inquiry's experts, Mr. Todd, argues in effect that there is no discernible competence standard which applies to risk assessors, as they were not required to be competent by the RRO, given the legislative intent was to enable the responsible person to carry out their own FRAs. Todd's analysis conflates the requirements of competency with the requirement to instruct a specialist. Given Dr. Lane's opinion that the FRA is the most fundamental of all fire safety duties, It would be a perverse interpretation of the RRO that it's required no competency in carrying out the FRA. The better view is that expressed by Dr. Lane, namely that every FRA must be competently carried out, albeit not necessarily by a fire safety specialist. The inquiry may, however, wish to question the wisdom of lack of requirement for a fire safety specialist to carry out the risk assessment, given the safety of others depends upon it. The risk assessor is the person best placed to judge the safety of the building in question, which may well have changed since the time of its construction or renovation. It seems to us that it would be preferable to recommend the amendment of the RRO to expressly require that a competent person carry out the FRA. And we would go further and require that such a person be a fire risk assessor, which should be a registered profession with defined educational requirements, given the risk assessor's centrality to fire safety. This suggestion does not exonerate Stokes. His characterisation by Dr. Lane as reckless in his unfounded assertions as to the nature of the cladding clearly stands, and his conduct was demonstrably inexcusable, given gratuitous failings such as cutting and pasting even from the FRA of another building, and for a 6-year period referring to peeps as going to be produced when he knew they had not been. To rely, as he does, on the fire brigade's approval of his FRAs is particularly distasteful, given LFB's criticism both of them and of his tendency to make unjustified statements. Anyone in the business of making fire risk assessments knows or should know that they are in the business of life and death. That particular métier allows no latitude for the sloppy approach adopted by Stokes, whose assessments were actively misleading in relation to peeps and lifts. His serious misstatement in relation to the cladding is also causative in the sense that it closed down a line of inquiry raised by the Shepherd's Court fire, which otherwise may well have been pursued to its conclusion. It cannot have been lost on Stokes that such statements were dangerous. The diametrically opposed opinions of Dr. Lane and Mr. Todd as to the standard of care applicable to fire risk assessors and TMOs on questions such as peeps and whether the risk assessor was required to consider the risk posed by the external wall raise an important question. You, sir, as chair, will need to consider whether the usual test of the standard of care as enshrined in Bolam and Friedman is apt in this case, namely whether a person's actions are condoned by a reasonable and responsible body of opinion within a professional sector. Grenfell is arguably that rare case identified in Belitho in which the body of opinion is not capable of withstanding logical analysis and may be rejected as not being reasonable or responsible. As Lord Brown Wilkinson said in Belitho, when the evidence shows that a lacuna in professional practice exists by which risks of grave danger are knowingly taken, then however small the risk, the court must anxiously examine that lacuna. We submit that where, as here, there is evidence of a body of opinion supporting what appear to be dangerous practices, you must anxiously examine the lacunae in the practices of the fire risk assessors and TMO in relation to peeps and FRAs. Whilst mindful that the inquiry is not to determine liability, the inquiry must nevertheless measure each protagonist's behaviour by reference to an applicable standard of care in order to ascertain responsibility, and so that the inquiry's recommendations will be meaningful. I turn next to the seminal failures of lack of leadership and failure to scrutinise, which infected both RBKC and TMO. Leadership on fire safety must emanate from the very top of an organisation. RBKC did not set a standard for fire safety nor give it priority except by lip service. It adopted PAS 7, which states that fire leadership must come from the top, in a document which in fact related to RBKC's commercial buildings, not residential ones. This immediately begs the question why there was not such a document in relation to residential properties, and RBKC candidly admits that there should have been one. Inevitably, the lack of any clear statement on leadership on fire safety led TMO to conclude that fire safety was not a priority, which was further reinforced by the lack of key performance indicators for fire safety. RBKC admits that it should have required KPIs for fire safety. The lack of leadership, which infected RBKC, also infected TMO's leadership, such that Ray was left to develop a fire safety strategy without top management review of it, as was required by PAS 7, of which Black was ignorant. Black depended entirely on Ray as to whether any fire safety issue should be presented to the board, and this absence of leadership inevitably sent a message within TMO's organisation regarding the importance of fire safety, as did the lack of resources allocated to the task. Similarly, TMO's executive team exercised no scrutiny over Ray or Stokes. Barbara Matthews was ultimately responsible for the discharge of all TMO's health and safety duties, yet lacked any training, and as a result, deferred to Ray and Stokes. The way TMO's executive team operated resulted in its board not being privy at the relevant time to important problems such as the Adair Tower deficiency notice and the Hodgson audit of TMO. RBKC has itself admitted to significant failures of scrutiny of TMO, but relies on TMO's board being kept in the dark as being a contributory factor to RBKC's inability to monitor TMO effectively. Such lack of transparency as between TMO's executive and its board originates, we suggest, in the Council's admitted failures to have a policy stating what it and TMO's obligations under the RRO were, and in the Council's failure to ensure that its housing commissioning officers received training on the RRO. Furthermore, RBKC Housing held an unduly narrow view of the extent of its responsibility for scrutiny and oversight of TMO. Johnson regarded the primary responsibility for monitoring TMO to lie with its board, such that the Council's role was limited to strategic oversight of the activities of TMO and not the granular detail of what the TMO was doing on a day-to-day basis. RBKC exercised no real oversight over the FRA process. It regarded the process as having been entirely delegated to TMO. The Council did not receive or read any FRAs. While Ray did not proffer FRAs for inspection, neither did the Council seek copies, even after the Adair fire and the consequent enforcement notices. Even if the Housing Department could credibly claim that it lacked expertise to scrutinise FRAs, there were others within the Council, such as its health and safety team, who had sufficient knowledge to assist. Yet the Council remained passive throughout the FRA process. By January 2010, Johnson was aware of deficiencies in TMO's historic FRAs, and while she and Black jointly wrote to the LFB, undertaking to address the problem, she could not explain why she did not ensure that TMO delivered on what it promised. Even the receipt of the deficiency and enforcement notices did not cause RBKC to question the adequacy of TMO's FRAs. The Council did not ask Stokes, in discussions with him after the Adair Tower fire, why critical items had not been addressed in the FRAs. The lack of scrutiny extended to the top of the RBKC executive. Paget Brown was responsible for ensuring his cabinet were performing their duties properly. He simply assumed Fielding Mellon was doing so, unless something to the contrary came to his attention. Paget Brown was unaware that KPIs did not cover fire safety. He knew a bit, but not a lot, about TMO's approach to FRAs, and did not keep tabs on the process. Following the Adair Tower fire, he did not ask what LFB's enforcement notices required or whether they had been complied with, although he was unaware of Grenfell's deficiency notice in November 2016. He believed this was not something that should have crossed his desk. He simply assumed, contrary to LFB's advice, that the Scrutiny Committee and Laura Johnson would scrutinise TMO's management of fire safety in purpose-built blocks of flats. RBKC has properly admitted that it allocated insufficient resources to scrutiny of TMO. Celia Calliscan was the officer immediately responsible for managing the contract with TMO. Historically, there had been 2 officers allocated to general housing needs, but the second requested voluntary redundancy and was not replaced for financial reasons. In practice, the day-to-day work of supervising the MMA was left to Calliscan. A considerably greater number of staff were dedicated to temporary accommodation, arranging accommodation for 2,000 households. By contrast, just 1 officer was primarily responsible for a TMO that managed nearly 10,000 properties across the borough. The Cabinet Member for Housing was inexplicably unaware of this. Viewed quantitatively alone, it was clearly inadequate for proper scrutiny of TMO. Laura Johnson thought resources were a bit light, but she did not share this view with anyone at the time and did not ask for more. The limited resources allocated to monitoring TMO perhaps reflect the limited degree of scrutiny its officers believed they needed to bring to bear. But it may be an indicator that no one believed themselves responsible to request more funding when an issue which directly impacted safety presented itself. Nobody at RBKC held responsibility for monitoring or scrutinising the adequacy of provision of evacuation of vulnerable and disabled people from general needs housing in the event of a fire. The focus was on sheltered housing. Although they discussed PEEPs for sheltered housing within LFB, it did not occur to them to ask whether these were being considered for residents of general needs housing. Councillors appeared similarly unaware as to whether TMO had a programme in place for PEEPs. For his part, Paget Brown simply assumed that LFB would come and rescue disabled residents, but he could not explain how he came to that assumption. RBKC denies being a responsible person and seeks clarification from you on whether TMOs, rather than councils, will invariably be the responsible person. This is not susceptible to a universal answer. The guidance underlying RRO makes clear that there may be more than one responsible person, and it is always going to be a question of fact as to whether the degree of control exercised by a body renders them a responsible person. We submit RBKC was, alongside TMO, a responsible person due to its having control over the maintenance budget and exercising decision-making power. Flat entrance doors are a good example. Following the Adair Tower fire, LFB reiterated the need to install door closers across TMO's stock and to implement a regular inspection programme. The LGA guide made clear such a programme was required. Instead, Johnson delayed the installation programme from 3 to 5 years and refused to fund an annual inspection programme without taking legal advice. She took no other advice as to the safety implications. This was, as Johnson accepts, clearly an error, and worse than that, it was reckless. Barbara Matthews took Johnson's decision as a direction to TMO. Matthews challenged LFB's requirement on the basis that the door inspection policy was not being applied uniformly across London, but did not in fact herself seek legal advice. Turning to Stokes and his FRAs, he should never have been selected as risk assessor for Grenfell, given his lack of membership of a professional registration scheme and lack of UCAS certification meant he did not meet TMO's requirements. Despite LFB's Burton raising concerns about Stokes on 2 occasions, including the quality of his FRAs with both Ray and Matthews, TMO failed to take effective action. In February 2016, Ray was expressly made aware of the urgent concerns about the suitability and sufficiency of Stokes's FRAs by Martin Dunn, a fire risk assessor. But Ray could not recall what actions she took in response and couldn't explain why she failed to escalate these concerns. Ray had inexplicably forgotten that in May 2017, she was told by Raymond Hilton that his review of 2 of Stokes's non-Grenfell FRAs showed they were not suitable and sufficient and had put TMO at risk. Stokes's methodology for his FRAs was flawed in at least 3 key respects. First, he failed to identify the occupancy profile, which is critical to any analysis of the risk posed by a building to its occupants. He claimed he was reliant on TMO to inform him of residents with particular needs and therefore did not seek up-to-date information. Stokes accepted, however, that each FRA for Grenfell contained the same information about residents which he'd used in his first FRA of December 2010. He'd taken this information from a meeting with Ray in September 2010, even though that meeting was unrelated to Grenfell, and he never updated the information. In the course of his 7 years as fire risk assessor, Ray told him of only 2 instances of disabled occupants across the entire stock, but it did not occur to him that this was odd. This is wholly unreasonable. Stokes's failure to instigate or advise instigation of any monitoring system of vulnerable residents is characterised by Lane as the failure with the highest potential risk to life. Todd agreed that most fire risk assessors would not simply have assumed there were no disabled persons, but instead would have asked about it, albeit he thought Stokes only needed high-level information rather than the details of each resident. As a result of Stokes's failure to ascertain the occupancy profile, the information on disabled people remained unchanged from 2010 and was wrong and outdated by the time of the fire. Stokes was clearly aware of his failure to identify the occupancy profile, given his advice to Ray not to answer LFB's request for information on vulnerable residents for its sprinkler initiative. Although he denied he was advising Ray not to identify any individuals, as that would prompt LFB to check why they weren't included in FRAs, that is the clear inference to be drawn from the email exchange and is deplorable. Second, Stokes failed to link FRA actions to the risk they posed if not cured. The most significant purpose of an FRA is to estimate the level of risk and provide clear guidance to reduce or maintain the risk as trivial or tolerable. Yet Stokes did not, nor did he advise how a failure to complete it would impact on risk level for the premises. Third, Stokes failed to ask to review the emergency plan for Grenfell and did not advise that one should be prepared. Stokes's understanding of the plan was that PEEPs would be provided for vulnerable residents, when this was not so. By definition, Stokes's failure to highlight the lack of evacuation procedure for the vulnerable resulted in his FRAs not being suitable and sufficient because they did not express the different risk level for those persons. In conclusion, the collective failings of TMO and RBKC to fulfil their obligations under the RRO as responsible persons are shocking both in volume and severity. Sadly, the evidence suggests that the problems witnessed by the inquiry are not confined to Grenfell Tower and that industry has much to learn in terms of the proper approach to FRAs, to emergency plans and to fire risk assessments, and fire risk management systems and adequate maintenance. As with Module 2, serious questions arise as to the testing and marketing of products, in this case door sets, and this issue represents a consistent pattern of dishonesty. We invite you to keep in mind that the devastating consequences of the fire in terms of its spread, breaches of compartmentation and systems failures were in fact foreseeable, not by lay people, but by TMO and RBKC tasked with keeping residents safe as responsible persons. The fact that each of these failed in that endeavour in multiple ways is evidence of the systemic nature of the problems, usually driven by poor culture and lack of competence. The RRO itself, as amended, is, broadly speaking, fit for purpose. It does not depend on the building regulations or building control because its focus is the safety of a building in question for its residents and visitors. Instead, the issues lie in the flawed culture and systems of the responsible persons and their agents. Those are my submissions, sir.
Well, thank you very much indeed. The next statement is going to be made by Mr. Friedman, Queen's Counsel. We'll just take a moment to wipe down the Council's bench, and then we'll be ready for him. Thank you very much. Yes, Mr. Friedman. Well, if you're ready, let's hear from you.
Thank you. Good morning. The primary duty of any landlord is to ensure their residents are safe in their homes. The duty can only be fulfilled where residents' views are respected and residents' lives are valued. That did not happen at Grenfell Tower. We say that it should have, and the fact that it did not, and that residents were made to suffer before this fire, and not just because of it, is a truth that needs understanding and recording. That suffering was in the conditions in which residents were made to live with no significant investment for 30 years. It was in their fears that their building was unsafe, and in their helplessness that their concerns were not only ignored but actively opposed by their landlord and managing agent, who could act with impunity and did, we say, act in violation of their human rights. And when we talk of human rights being at stake at Grenfell Tower, we mean three things. First, there are fundamental rights that are common to all human rights treaties enacted since the Second World War: the right to life, the right to private life, respect for a person's home, and freedom of information to enable rights to be protected. These rights have their roots in all major faiths and cultures, but they mean little without deliberate commitment to equal treatment in their application. That requires that everyone's enjoyment of rights shall be secured without discrimination on grounds of race, language, or disability, but also other aspects of their situation, whether it be their immigration status or their opinions. Second, human rights are the reason for the various health and safety laws that the inquiry has looked at across its modules: the building regulations, the construction design management regulations, and the fire safety order, or RRO. These texts contain technical rules, but they are ultimately about the protection of life and human security. Of course, they are not seen in that way nearly enough, and indeed too often treated as unnecessary red tape. But they are part of the state's duty to establish a framework of laws, precautions, procedures, and means of enforcement which are there to protect people. Finally, as we are not all the same, our level of safety in buildings can be different. The Equality Act formalises that if you stubbornly treat people uniformly, regardless of their differences of race, gender, and disability, then you can risk penalising them for those differences. Likewise, if you deliberately remain ignorant of the characteristics of people under your control, such as their disabilities or features potentially connected to their race, like language and recent migrancy, then you will never know if you are discriminating against them. Drawing matters together, fundamental rights, health and safety, and equal treatment were part of an overall value system that should have served residents' rights before the fire, but did not. The foundation of the system is respect for the inherent value of the individual as a human being. The residents at Grenfell Tower were not treated with that respect. Instead, the specified consultation rights that required direct resident involvement in the project management of major works on their own homes were completely discarded. Non-compliance with fire safety was deliberately hidden from residents, and differences in the resident population, including race and disability, were given no real thought at all. In a major capital city, in one of its wealthiest boroughs, those in government acted beyond the rule of law. And one of the main things that causes outrage amongst the residents who were ill-treated in this way at the time is that but for the fire, nothing would have been done about it. RBKC was home to a governing culture that was opposed to residents' rights and so abused its powers. That abuse contributed to this disaster, and the inquiry should document that aspect of the disaster's causation alongside everything else. To understand the sequence of events that led to the disaster, it's important to analyse the power structure on which the decision-making process was built. Most of Phase 2 to date has questioned the competency and ethics of private actors, but Grenfell's residents lived under the exercise of public power. Section 27 of the Housing Act 1985 permitted RBKC to set up the TMO as its agent, but the principle of arm's length management never allowed the council to relinquish its legal duties. Equally, the TMO may have been a private limited company acting under the Modular Management Agreement, the MMA, but as the agent of the council, it exercised public functions, and the power it held over residents was the power of public office. This was never an ordinary landlord and tenant dispute. It was always about the relationship between individuals and the state. But without the robust protection of their rights, in a local authority that paid them little regard, residents could quickly be marginalised, and so it turned out. Starting with the refurbishment. There is a legal duty on local authorities under Section 105 of the Housing Act that requires them to make arrangements to ensure that secure tenants are consulted about the conduct of major works and that their views are taken into account. The details of those arrangements must be published. The way in which RBKC chose to discharge the duty was contained in the text of Schedule 3 of the MMA that dealt with the rights of residents to directly participate in decision-making on major works. RBKC did not refer you to this schedule in any of their original statements, but they now concede that the degree of consultation envisaged in the schedule was not achieved. That is a confess and avoid admission, which overlooks the illegality, unfairness, and causal implications of what was denied. To appreciate the wrong done, you need to consider the terms of the schedule. Under the heading Client Review Group, it reads that the project manager was to, quote, decide whether to establish a client review group or steering group for the project to be chaired by a representative of the Residents Association, with the role to act as a client for the project, review progress in implementing the scheme, and focus on those issues which directly concern residents. If it was decided not to establish a client review group, then effectively, one better, the Residents Association was required to be asked to nominate a representative to directly join the project team. Thereafter, the Residents Association was to participate in the appointment of contractors and to either attend the site meetings or to be briefed before and after them. Potential savings in the contract were to be discussed with the Residents Association before any savings were implemented. Finally, the refurbishment was to undergo a formal post-works review that asked residents for their views on the works. Panel, whatever that was, it was not coffee mornings and newsletters. Residents spent more than 2 years advocating for the recognition of some form of collective status in order to be properly consulted when the terms of the schedule positively desired it and to a level very much greater than was ever afforded. The discarding of Schedule 3, without any justification or reasoning, was an unlawful breach of Section 105 of the Housing Act. The failure to tell residents of their rights under the schedule was also unlawful. Instead, the management arrangements for the refurbishment were allowed to progress, with residents effectively locked out of all the practical conversations. there's an additional layer to this. The construction design management regulations require the TMO as the client to make suitable management arrangements. And the guidance reminded the client that the way it behaves can make a difference to the quality of the works. Management arrangements that exclude a party that was anticipated to have a participatory role in the project chain should not be deemed suitable. Neither should it ever be regarded as suitable for the engagement of the architect and main contractor to deliberately circumvent public procurement rules. The evidence shows that resident engagement in these works was deliberately limited for a number of reasons. There was discrimination against active residents like Edward Dafan and Shah Ahmed for the flagrantly abusive purpose that they might query the decisions being made. But the TMO especially did not want their critics looking under the detail of these contractor appointments because they did not want to be found out for doing wrong. In this entirely unacceptable secrecy, motivated by reasons of bad faith, the consequence was to prevent residents from discovering three fundamental features of the refurbishment identified in the Module 1 evidence as causative of the fire. 1, the lack of experience of the architects. 2, the replacement of zinc FR with Renabond ACM for reasons of cost. And 3, the draft and qualified terms of the Exova fire safety report, including the failure to action project meeting agreed steps to properly engage a fire consultant. As a result of this lack of candour, the residents, including people who through previous hard knocks were determined to stand up for themselves, were disempowered from securing answers to the following questions. 1, have the architects done this before? 2, what are the dangers, if any, from the substituted cheaper cladding materials? 3, why have you not completed a fire safety strategy report, which in express terms tells us is incomplete? And 4, what happened to the fire consultant you repeatedly said at project meetings should be appointed? These questions are blatantly obvious. They should have been asked by the TMO. Transparency would have enabled them to be asked by residents who did not trust what was going on in that refurbishment and had much more incentive to ask when they weren't asked properly. And once those questions were asked, residents, and especially those residents who you know, would have been more determined to act on any unsatisfactory response than the TMO proved to be. Cumulatively, we say that the breach of consultation rights and bad faith secrecy were not just context but cause. The failure to ask those 4 questions allowed the TMO to be unshaken in its alignment with its contractors and not to progress finalisation of the Exova report. RBKC also avoided being forced into considering these issues, even if only to placate public pressure. Whatever the cause and fate of Claire Williams' Lacknell moment email in November 2014, her sharing of the moment with Ryden, as well as resident representatives on a project team, would have required a more studied and formal treatment of the issue. There was also no post-work satisfaction survey as mandated by Schedule 3. Had it occurred, there was a further opportunity to learn of potential risks to fire safety. Overall, it is beyond doubt that the residents were excluded from disclosure of information to enable scrutiny of primary causes of the fire that matter to their fate. That fault was wrong in itself and of more than likely causative effect. The next body of residents' rights concerns fire safety. To hold the authorities to account, residents needed the information to do so. There is a general legal doctrine that rights protections must be practical and effective and not theoretical and illusory. While the doctrine applies to many aspects of the management of health and safety by RBKC and the TMO, it had significant relevance to the extent to which fire safety information was deliberately withheld from residents or other oversight bodies, whether the TMO board, the Council Scrutiny Committee or the LFB. When we say that the failure to consult with residents caused the disaster, we include that aspect of the breach of their fire safety rights. All parties address you in detail about the commercial decision in March 2017 to limit the defective self-closer replacement programme to no less than 5-year cycles with no inspection arrangements in between. The senior relevant officer at RBKC, Laura Johnson, defended her decision before the inquiry on the basis that she assumed it would be challenged and, pending that, did nothing to establish its legal or safety implications. We say her approach showed reckless indifference to the illegality of her decision. But as regards causation, who did she think would challenge it? Residents knew nothing about it. Neither did the TMO board. She never established whether the LFB would be told, and it wasn't. Robert Black, who ran the TMO and was jointly liable under the fire safety order, never challenged the adverse safety implications of Johnson's self-closer plan. In answer to the chairman's questions, he could have registered his dissent either with her or with the cabinet, but did much worse. In an email of January 2017, Black positively encouraged Johnson to galvanise local government politicians against what he characterised, and she agreed, with the unaccountable and wrongly non-negotiable efforts of the LFB over the issue. This evidence cannot be sugar-coated. Johnson was a powerful figure in London social housing. Black was the CEO of the biggest TMO in the country. They were far happier to limit disclosure, lobby the establishment for change, and wait to see whether anyone would stop them. Not only were residents not told about the decision, but throughout these debates about doors, there were express and implied blaming of the victim. Rather than Edward Defan's complaint about door 136 being understood as a matter integral to fire safety, it was dismissed not once, not twice, but through all 3 stages of the complaint systems. Both before and during this inquiry, TMO witnesses alleged that residents would not grant access to check their door closers. No one accepts that. Stokes never raised resident refusals as a problem, relying on, in his words, potluck as to who was in at any given time. Residents were not properly informed of the importance of door closers, and no system was ever implemented to facilitate access. All the BSR submissions show that in various ways, RBKC and the TMO were in continuing non-compliance with the fire safety order before the Grenfell Tower fire. That was wrong in its own right, but they also took steps to conceal their non-compliance from residents. That is the impunity part of this. Aside from the door inspection issue, the Salvus Review of 2009 and the Hodgson Report of 2013 that told that the TMO was in breach of fire safety law, but were bare summarised to the TMO board, were withheld from the Housing Scrutiny Committee and never made public. RBKC and the TMO remained in breach of a deficiency notice on the smoke ventilation system for many months. They waited to see if the LFB would follow up, with Ray and Williams writing casual emails, hoping that their luck would hold out and that there would be no fires in the meantime. Williams expressly opposed Edward Defan's Freedom of Information request in October 2014 because she did not want him to find out about the ventilation problems. This was organised and deliberate non-disclosure. On doors, they now accept that the board was kept in the dark. The November 2016 deficiency notice on Grenfell Tower, including defective doors in the building, remained unremedied before the fire and was neither disclosed to the residents, nor the TMO board, or the Council Scrutiny Committee. Going back to 2014, there is a minute of the TMO Health and Safety meeting attended by Madison, Ray and Jevons that detailed a decision not to disclose the level of outstanding fire risk assessment actions to the LFB in order to avoid, quote, scrutiny and, quote, possible enforcement action. The other participants won't recall the event, but Michael Lyons, as a qualified health and safety expert, must have demanded its recording to reflect a decision which he did not agree with, and now everyone else is ashamed of. Francis O'Connor and Edward Defan only ever saw one fire risk assessment. Once seen, they blogged about it critically. That triggered Ray for the first time preparing a list of outstanding actions, but she deliberately withheld the full picture from RBKC. The gag blog led Peter Madison to direct his staff in the future to keep such matters in-house. Black confirmed that Madison was uncomfortable because it showed some of his team hadn't been doing their job properly. As with the failure of candour and transparency on the major works, the lack of candour on fire safety to residents was causative in that it kept criticism and scrutiny at bay. It excluded the capacity for residents to monitor and influence compliance, either by representation or, if necessary, legal action. With greater transparency, a campaign for compliance could have been rigorously pursued by residents to protect themselves because they didn't believe others would protect them. Residents had a right to be informed and prepared for a risk on their own terms and not on the secretive and defensive terms of those who governed them. That brings us to residents' rights to equal treatment. The duties contained in the plain words of the fire safety order cannot possibly be discharged without knowing the resident profile of the building. The TMO were advised by Salvus in 2009 to develop formal procedures to deal effectively with fire safety issues associated with disabled or vulnerable tenants and leaseholders, and to include options from relocation in severe cases to the provision of specific personal evacuation plans, PEEPs, in less serious cases. What we now know is that the TMO did nothing. Overall, the TMO's basic answer for doing nothing, insofar as it was ever considered, was that the stay put principle meant that nothing needed to be done. However, instead of declaring transparently that nothing would be done, the TMO pretended that they were doing a lot. The fire risk assessments for Grenfell Tower contained 3 fictions. 1, the TMO had a comprehensive programme to gather information about tenants, including those with disabilities, and which would be used for the development of PEEPs. 2, both lifts were firefighting evacuation lifts, which could be used as part of the evacuation strategy for disabled persons. And 3, TMO employees would arrange for a general evacuation of the whole building if appropriate to do so. In fact, there was no relevant planning or provision at all for disabled residents. No PEEPs were prepared. Employees were not briefed in any way about assisted evacuation. And description of the lifts as firefighting evacuation lifts was wrong, and Janice Ray knew it was. And it was a serious assessment flaw because it envisaged that residents could be evacuated that way during a fire when they could not. The fulcrum of the continuing fictions contained in the assessments was Janice Ray. She knew that the stay put policy still required consideration of the possibility of evacuation. She was aware that the duties of responsible persons under the fire safety order applied to all persons in general needs housing. She understood that the evacuation planning could not be dependent on the LFB, and she was advised that the Equality Act duties were engaged. Importantly, Ray accepts that she did not consciously justify the TMO's approach to PEEPs in general needs housing by reference to paragraph 79.9 to 11 of the LGA guide, which we say unlawfully suggested that there was usually nothing to be done for vulnerable residents in high-rise buildings because it was unrealistic to make any special arrangements for them, be it PEEPs or otherwise. The TMO's failure to offer PEEPs had nothing to do with the LGA guide. There was no reference to it in the fire safety policies. There was no TMO opposition to LFB advice in 2012 that PEEPs were required for vulnerable residents in high-rise general needs housing. In fact, the TMO gave assurances to the LFB around the time of the guide's publication that it would be proactive in identifying vulnerable residents requiring PEEPs. There was, though, no system to identify the vulnerable, no publicity that PEEPs were available, and no system, let alone training or internal discussion, to ensure that when vulnerability was discovered, a PEEP would automatically be considered. We say the root cause of this was the disconnect between housing allocation that relied on disability and vulnerability data and housing management which discarded it. The disconnect including the need to consider reallocation based in extreme cases once people were living at risk in the building, falls within the terms of reference to the inquiry because it was surely causative of death. Salvus advised the TMO of the link in 2009. The issue was never binary, as some residents would have been content to remain in Grenfell with PEEPs and other supports, while others would not, or even should not, because the risk to life was too great. The overall failure to conduct any assessments across Grenfell Tower is what constituted a systemic breach of the right to life of disabled and vulnerable residents. This failing breached the fire safety order and discriminated against those relevant persons whose additional fire safety needs were disregarded. The TMO and RBKC now seek to draw comfort in the do-nothing approach advocated by paragraph 79.9 of the LGA guide, when it was completely out of their mind at the time. Colin Todd's evidence is legally wrong, in conflict with all other published guidance, and takes no account of equality law. However, the ongoing fault, and indeed scandal, lies with government, which for over a decade now, and over 4 years after the Grenfell fire, has failed and still fails to declare that part of the LGA guide unlawful and unacceptable. That is why we say to the panel that if you agree, you should write to the Secretary of State and express your views now, rather than wait to publish it in a final report. And of course, the importance of this is both the more than 41% of adults who died at Grenfell Tower who were mobility or otherwise impaired, and the people who stayed with them. To name only some, Fatima Afrasyabi stayed with her sister Sakina, Mariam El Grari stayed with her mother Esla, Sotu Abu Fras and Isra Ibrahim stayed with Mrs. Al-Sanusi. All of the Shukairs stayed with their mother and grandmother, Mrs. Syria Shukair. People together who should have been assisted with pre-prepared planning to assist each other to escape. This again involved a failure to properly consult with residents in a way that caused their death. Panel. That sets out why we say that alongside the Module 1 and 2 negligence and discrete wrongdoing, the Grenfell Tower fire was a human rights disaster. In multiple ways, the rights were breached and those breaches were causative. These are matters that go to the heart of safety in the modern built environment, and compliance with them needs to be treated the same as the building regulations or other rules that the inquiry has studied. But this is not just about compliance. It is about a profound failure of governance. In the years before the disaster, there was an abuse of power that involved the orchestrated defeat of the residents who were in defiance against their ill treatment. That's what we mean when we say that RBKC and the TMO was not just breaching residents' rights, they were actively opposing them. First, the residents were largely regarded as an inconvenience to be managed rather than human beings. The fundamental feature of that attitude is the characterization of the refurbishment as an act of generosity. In truth, money had become available from sales at Elm Park Gardens, demolition was more costly, and residents had no significant investment in their building for over 30 years. The situation had become untenable. More broadly, the negative stance of the TMO to proper resident consultation, safety and compliance reflects an organisational culture and a set of attitudes. Its priorities, set by RBKC, were to project manage on time and to budget with a view to sustaining its asset management future. Its deeper definitions of success were to control resident dissent, protect its own reputational interests, and help the council to avoid political embarrassment. Somewhere along the line, a disdainful attitude to residents became institutionally acceptable within TMO ranks. So when Siobhan Rumble felt able to express disdain about Edward Daffan's reference to some like conditions, or to say that she had better things to do with her time than deal with Miguel Alves and the GTLA, it was because she was working in an organisation whose culture permitted her to do so. Second, the governing structure was presented as resident democracy, but it was anti-democratic. Nicholas Paget Brown accepted in hindsight that it was far too big. The motivation for creating a monopoly borough-wide TMO was never about democracy but economies of scale. The TMO executive deliberately withheld information from its board, but also from residents and often on fire safety. And it did so in express terms because it wanted to evade resident criticism. Third, RBKC was guilty of lack of oversight of an organisation they knew was not being managed by a robust board, but run by executives without challenge or scrutiny who did not deserve the arm's-length freedom that councillors and the RBKC officers afforded to them. The Momoli report of April 2009 highlighted a main complaint of residents to be lack of contractor supervision, bad workmanship by contractors, and a failure in monitoring of contracts and works. In 2012, the TMO was still seen by the council officers as from top to bottom, having no experience in regeneration works, including the risks associated with them. Strikingly, Black's interpretation was that the RBKC was neither particularly keen nor impressed with the Momoli report. If that is right, that he was getting that message through informal contact with RBKC, that effectively residents' opinion was not important, then that is something that needs to be drawn out. Effectively, he was being told his job was to keep resident disquiet under control. Fourth, there was a denigration of dissent. Claire Williams confirmed that upon joining the TMO, she was briefed on the Grenfell Action blog, which Edward Defan was described as being the main mover. After some pretense by TMO witnesses, it was conceded that the blog was being monitored. Ryden was equally warned against a gag from the initial interviews onwards, and later encouraged to guard against the so-described rebel residents, which included Defan, but also David Collins. Laura Johnson, as that day-to-day senior oversight council officer, counselled Black in January 2017 that Grenfell was a bad-tempered place, with residents complaining about minor matters, with their own agenda, who were not to be taken seriously. Given the imbalance of power, this was not disagreement amongst equals, but flagrant political discrimination over the treatment of issues that directly impacted on safety. In Edward Defan, the TMO and RBKC were determined to shoot down the messenger. You have multiple sources of evidence, including a range of people from ethnic minority and disability backgrounds who wanted a collective voice and not just to rely on individual complaints. The attempted rubbishing of Defan comes from an organisation who knew next to nothing about the needs and vulnerabilities of its residents. They were wrong to denigrate an opponent like this, a registered social worker, who was well connected to people across the estate and who could and did undoubtedly garner the views of numerous residents and articulate them to the authorities. When the information was made available, GAG and others did what they could to hold the TMO and RBKC to account. In turn, the authorities were determined to shut all of them down. And we do mean everyone. It did not matter if you criticised with caustic words, polite ones, with the benefit of council-elected office, or with professional credentials, or indeed the experience of living in the tower that these people did not live in. No one got through. And in the end, at least until the fire and the outcry that followed, the public landlord and their agent had won. There are a number of examples cited of how residents were systematically dismissed before the fire in a way that otherwise might have stopped it. We focus on just two. First, the TMO and RBKC fixed the outcome of the Grenfell Compact campaign for an independent assessment of the refurbishment as requested in the petition of November 2015. The joint minutes of the RBKC TMO meeting of December 2015 described the petition as the negative influence of Edward Defan and Councillor Blakeman. You have the evidence panel of the many residents who were involved, including 20 who are now dead or bereaved, and the events leading up to that petition are caught on film by Constantine Grass. Robert Black was informed over the new year that the RBKC powers that be were set to manage resident opposition. This occurred through an email exchange between Quinton Marshall and Rock Fielding Menon, where the chairman of the scrutiny committee assured the cabinet member for housing that a majority of the committee meetings could be pre-briefed to understand how to play it. The meeting on 6th of January 2016 was duly stage managed. Laura Johnson delivered a summary in response to the petition that played up the very large budget. Her report claimed that the TMO had worked closely with Ryden and the residents of Grenfell Tower, and even in her evidence to the inquiry, she did not treat lack of consultation in general as a serious concern. Defan, who did complain about consultation in his speech, was cut short by Marshall in his presentation of the residents' case. Johnson and Black treated the event as a vindicatory moment. Defan recalls them smiling at the meeting because they knew they had won. Quinton Marshall's attitude was expressed in a private email to the MP Victoria Borwick, written even before the TMO internal review had been completed. He euphemistically minimised this as only his initial conclusion, but it is clear that he had already formed a view that a large sum of money had been spent. Residents' complaints were, quote, wild, unsubstantiated and grossly exaggerated, and so he was not massively sympathetic. The TMO's internal review was cursory and ineffective. The review members' only source of information was provided by the executive team they were supposed to be reviewing. Madison admitted important documents showing the TMO's great resistance to any collective consultation, complaints detailing bullying and harassment, the fire safety concerns about the new floor numbering, and the separate call for an independent assessment of fire safety arrangements. Review members never met with compact members or any Grenfell residents in what was a choreographed short trip to the tower. The outcome was an internal report by the TMO that praised the works, including the consultation that underpinned them, and took no account of the fire safety features that had been raised. Councillor Blakeman was blocked from speaking against the outcome at both the TMO board and the subsequent scrutiny committee meeting, and for several months, until matters died down, the report itself was kept confidential. The second respect in which residents were dismissed was the casting aside of the complaints about fire safety that could be made due to what was visible to them. On this, we end with the manner in which the gag blog was ignored, and in particular its November 2016 post Playing with Fire that predicted a disaster as the only means that would bring the TMO to account. There is an old English legal phrase, to raise hue and cry. It refers to pursuing a criminal with cries and sounds of alarm. In ancient times, it was the duty of any person wronged or discovering a felony to raise the hue and cry, and neighbours were bound to come and assist him or her in the pursuit and apprehension of the offender. The gag blog was a protest against disempowerment, but it was also the raising of hue and cry. It sensibly questioned the adequacy of stay put following the Shepherd's Court fire, sensible in the sense that stay put should have been the subject of pressing questioning at that time at all levels of central and local government and amongst all management and expert stakeholders. In the aftermath of the blog, with Black's knowledge, Janice Ray misled Councillor Blakeman about the LFB's assessment of Adair Tower. She withheld from her an outstanding deficiency notice critical of the lack of fire action notices and self-closing devices at Grenfell Tower, issued just 1 week before the blog. She also told Blakeman that the refurbishment works had been scrutinised by fire engineering companies, but she had not properly considered for herself the Exova reports, which she now accepts left open the question of whether stay put would be appropriate. All in all, because they maligned the messenger in a Cassandra-like tragedy, the TMO discounted and cursed the message, and RBKC positively encouraged them to do so. I want to conclude with how Edward Daffan completed his evidence to the inquiry by pressing the relationship between the ill treatment of residents and causation. He said, They didn't treat us with respect or humanity or empathy. And if they had done, we wouldn't be sitting here now. The culture of the KCTMO, the lack of scrutiny by RBKC is believed, I believe, and I believe many residents believe, to be a causative factor of what happened on the night of the fire and what led to the fire. And I just ask you to bear that in mind. Panel, the constituent parts of that statement are important. First, the reference of respect, humanity, or empathy are all complaints of a violation of human dignity. Throughout the evidence, there were assumptions not only of residents being difficult, but they had nothing worthy to add, would not understand the technical issues, and could not be trusted in their judgment. They certainly were not regarded as clients, collaborators, and co-authors in their destiny, all of which are central to a modern notion of human dignity. Difference, including different categories of residents, including that different categories of residents would find it difficult to complain, or in an emergency find it difficult to escape, were damningly given no real account. Second, the violation of human dignity was born out of the culture of the TMO and the lack of scrutiny by RBKC. This combined form of government involved an elitist mentality that did not regard the governed as their equals. But the mentality was also corrupt because it play-acted as resident democracy when it was no more than devolved management. It manifested flagrant errors of public law and breaches of the basic standards of good administration in its denial of fairness, transparency, and impartiality. And over lunches, emails, meetings, and after a time without even needing to say it, it became the norm to be dismissive of resident critique of the very wrongs it is now unable to defend. Third, disrespect of human dignity contributed to the cause of this disaster. RBKC and the TML held a range of biases and prejudices that underpinned their exclusion of meaningful resident influence over construction and fire safety management, including denying sufficient access to information concerning it. This meant that residents were unable to call the landlord, manager, or contractors to account, who in turn, prior to the fire, were able to act with impunity. A form of government that was truly concerned about life, dignity, and security would not have acted in this way. The inquiry decided at its outset not to investigate broader social housing policy. Instead, it has analysed the fatal harm done to one particular, predominantly social housed community in a single building under the authority of a particular local council. However, an explanatory narrative of the Grenfell Tower fire inescapably leads to the account of matters that have a further societal reach. Whether they are able to admit it or not, the reason why RBKC and TMO government acted as they did is that they were joined in seeing this refurbishment as an act of municipal generosity, not critical and long overdue investment, but a gift. They were genuinely affronted that, in their eyes, the investment in Grenfell was treated with anything other than gratitude. The residents on the receiving end of this approach were denied a proper voice or agency as equals in their fate. The cost of causal consequences to the fire is that the makers of the so-perceived gift were unable to comprehend and therefore inhibited in properly examining its inadequate and potentially dangerous qualities. The inquiry's map towards its final recommendation should be guided by acknowledging that the TMO and RBKC were playing with fire before the disaster, not just because of their gross failures to manage fire safety, but because they lacked respect for the residents that would have civilised their power. With recklessness and neglect, they led a line of architects, builders, corporate interests, and other professionals who, like them, failed to acknowledge that the individual human being and their safety should have been the ultimate focus and absolutely central to all that they did. There must be a deeper appreciation and enforcement of that truth. It has to be at the heart of the cultural change that makes real any commitment to ensure that the terrible events at Grenfell Tower never happen again.
Mr. Friedman, thank you very much indeed. Well, at that point, we'll take a break for for the morning session, and we'll resume at 11:30 when we shall hear from Mr. Mansfield, Queen's Counsel, on behalf of other bereaved survivors and residents. So 11:30, please. Thank you. Now, before we hear from Mr. Mansfield, Mr. Millett has one small matter to deal with.
Yes, Mr. Chairman, members of the panel, it's a correction to the transcript from this morning. During Ms. Barwise QC's address to the panel, she made a slip of the tongue at line 15 of page 15 of the raw transcript from this morning, in which she used the word within in the context of the LFB. She said within LFB, and she meant with LFB, which is rather different. One can see that. So subject to that change should be made on the written transcript, but also, of course, will now appear on the video, so everybody knows that correction has been made.
Thank you very much. Well, Mr. Mansfield, you're
Yes,
please begin.
Excuse me for sitting down.
Quite all right.
That doesn't indicate I'm going to be prolix, hopefully. And in fact, having listened this morning very carefully, I've had to do the usual red pen, and that maybe shortened matters rather than lengthen them. However, with your permission, I would like to start with another fire altogether. I don't want to worry you by the thought of another inquiry, but there was a fire this year which has a relevance to this inquiry in the sense it begins the process of understanding those matters you've already heard about, and a little more you'll hear about now. It happened in May of this year at New Providence Wharf in London. This was a new build, 2005. It was 19 stories high, so it's a high rise. And it was during daytime rather than nighttime. A fire broke out on the 8th floor on a fuse board. And as you yourself said in the Phase 1 report, often the fires that we're talking about begin as fairly ordinary, perhaps rather small, fires of domestic items. The fuse board in this case is what happened. But what happened thereafter is of interest because we talk a lot about compartmentation, but it was breached in a very simple way, which is often forgotten when one deals with regulations and whether an exterior wall is comprised with compartmentation or not. And it happened in another case as well, that's Shepherd's Court. Namely, the problem there was an open window. Very simple. And it so happens, an open door. So one can see that whatever regulations you may have, at the end of the day, you are dealing with human situations which have to be countenanced, because there's often a tendency to think, oh, well, these fires are not very common. And really they're so uncommon that perhaps we don't need to worry too much. But and compartmentation is the answer, the fail-safe, and one can see straight away it may not be. But what is even more interesting is that what failed there this year was a central failing in this case. Namely, the ventilation system didn't work. It wasn't triggered by a smoke detector. Now this is 4 years after Grenfell. And again, I'm not being particularly critical about this fire. This material is in the public domain. The London Fire Brigade have done a public report which one can read about this. However, the smoke and the fire travelled up the outside of the building from the 8th to the 11th floor. And it did so because there was inflammable, combustible materials on the outside. This time, not so much the cladding itself, but the decking, the wooden decking on all the balconies, which had been warned about a year before, but was still there. Now, what's happened since, I don't know, whether it's actually been got rid of or whatever. So there was combustible materials known about on the outside of the building. On the inside of the building, the ventilation system wasn't triggered, so the smoke travelled up many floors above the original starting point of the 8th floor. Following on from that, before the fire brigade got there, did they stay put? No, they didn't. And what is interesting is that in most of the fires, if not all, that one can trace that have happened since Grenfell, people have not waited to find out. The scenes are emblazoned on all our memories, I dare say. And so the instinct, we say natural and important, is to get out. 67 people got out. The fire and rescue service sent more appliances than they did in Grenfell, and more people were rescued as well. But some were hospitalised, not many. However, what is I finish on in relation to this is an important factor, and it echoes and is redolent of what you've already heard, namely, there had been another fire 2 years before. Again, you're going to, if you are not aware, I'm sure you are, that is a feature of this case, only it wasn't 2 years before, it was a long time before, in 2010, and I'll come to that in a moment. So there was a fire. The tenants, this wasn't social housing, but it matters not. The tenants and residents had already been pointing out that there were deficiencies and there were concerns. And that is why we emphasise what has just been said to you about the vital role that residents and tenants have to play. And it's such a vital role that we submit equally. It is a causative factor. And when a colleague, Adrian Williamson, was making his closing submissions in relation to Module 1, he made it very clear that we wouldn't be sitting here if people had listened, and not only listened, but acted upon what the tenants were saying. And also you'll find that echoed by, and I gather certain others are relying on Mr. Todd. Well, it was Mr. Todd who said, effectively, he wasn't saying it particularly about Grenfell, but he was saying it about Lakanor House, that the 6 deaths there could have been avoided. In the sense he put it rather differently, but the essence of what he was saying was, basically he felt there was every prospect that they could have been saved if the tenants had been listened to. And he said, in addition, that he'd been saying that for 20 years. It's quite apparent that some people have not been listening. And so whilst it's possible, obviously, to relegate tenants, which we say is what's happened, they have to be made centre stage. And so looking at that one fire that's happened this year, and of course you'll be aware, because of the difficulties facing people living in known buildings with combustible material, of which there is at least another 400 blocks, probably very many more. There's no register because people are reluctant to obviously indicate what they may have on the outside of or at least owners are, on the outside of their buildings. So therefore the centrality of what we're saying is that these things can happen again overnight. There are other blocks that are susceptible, and that this may encourage, when you're considering this module, perhaps before the end of the inquiry altogether, that there are things you might want to say at this stage on an interim basis with regard to how these matters may progress. And may I, as a footnote to this, say, of course, we're fully aware that there is a quarterly review of progress on your recommendations from Phase 1, and the most recent one in September this year indicated that, of course, there has been a reappraisal of the stay put policy, which I'll have to come back to, but it's not an essential feature of what I have to say, but it is worth noting that it is now recognised, even if you have compartmentation that can be compromised with the open window or the open door, or for other reasons of which you're very familiar, degraded materials or wrong materials in the first place. And that therefore That being the case, being aware of what's possible through reappraisal of evacuation, so you now have the possibility, simultaneous evacuation is what happened at Providence Ward. Simultaneous, partial, zonal, they're all in the quarterly review that obviously matters are shifting. But these are matters that need to be, if I may say so, some of them decided rather earlier than the report itself because of the people who are sitting in jeopardy as I speak to you today. So may I pass from that example of why it's so important, the issues that we've raised. I would like to and say straight away that what I'm saying to you is not only tailored to what has already been said this morning, it's also tailored to our written submissions. So I'm not going to repeat those word for word at all, because that would take another 2 hours. So I'm certainly not intending to do that. But I would like to make reference to them, just to sort of echo what's started in the written submissions applies here as well. There are some general overview points that I would like to impress upon all of you. The first one, really I can run the two together. We say on behalf of the families that the tower, Grenfell Tower, was unfit for purpose. And we say it was unfit for purpose in the sense that it was not a safe environment. And therefore, there should not have been occupancy. And we say over actually a rather long time. We've put the time, as it were, frame in the written submissions between 2009 and the fire itself. And you may say that is not an arbitrary date. In fact, it's much longer than that. But those are dates which are very familiar to you because that's the date or the year in which the CEO, Robert Black, was appointed. That's the year, almost at the same time, that the Mamoli report is made and submitted. But it is also the time of the same year as Salvus and all the other things you've heard about. So 2009 is a very important year. 2010, which I'll be coming to in a moment, of course, is the following year, but many more things happen after that, including a fire at Grenfell Tower itself. So we start with 2009, go up to the fire, in relation to the tower itself, unfit. And we can accumulate all the factors, but I'm only going to light on one. And that is throughout the whole of that time, there was not a fit for purpose ventilation system. Beyond economic repair for most of the time, and they knew it. By they, we adopt the position that RBKC and the TMO shared responsibility. It really shouldn't take an act of legislation to work this one out, because actually if RBKC are effectively the owners of the building, they can't delegate everything away to somebody else, shut their eyes and say, well, they're dealing with it. Sorry, the responsibility is jointly shared. And so therefore, the joint responsibility for the unlivability, the uninhabitability of the Grenfell Tower lies with that joint authority, RBKC and TMO together. And we say they weren't fit for purpose either. The building wasn't, and neither were they. And perhaps it hardly behoves me now to summarise everything you've been listening to this morning, but perhaps just sitting back for one moment. Basically, non-compliance with the RRO is a starting place. The employment of Mr. Stokes, we say a disaster and catastrophic and dangerous. For reasons that have been explained, that he was reckless with regard to his FRAs, that he was at the highest risk when it came to the vulnerable sector of the community that resided in this tower, of which we've given details in a schedule already. So therefore, we say there can be little doubt about the unfitness of the tower and the unfitness of that joint authority. And they should have faced up to the responsibility, and even now they're trying to argue about which of them is really responsible. One would have thought by now they'd have worked that out without being nudged by regulation. So I pass from the unfitness points for the moment to two other related points. And these are, you've heard mentioned, but we say they come at the top of the overarching, if you like, precepts that we would ask you to consider. Firstly, there's the question of mindset is really very important. A lot is said about it, and people acknowledge it, but at the end of the day, nothing much happens. And mindset here is important, as I'll come on to in a moment, because it governs how people govern. And if you have a mindset that does not include health and safety at the top, or very near the top, as a matter that influences how you approach the building and the community living in it, then that mindset has to be changed. And of course, one of the things that the London Fire Brigade said about the new Providence Wharf was that the mindset about health and safety has still not shifted enough. There's talk about it, but one needs to see implementation, which leads to the last of the 4 points I'd want to make at the start. And this relates to the tenants themselves. We strongly argue, no, not just on the back of what Mr. Todd said or what Mr. Williamson said, or for that matter, Eddie Defan himself. But we say it's an obvious feature. We say, particularly of social housing, particularly of, I call it the vertical village. They're living in the building. And if you live in the building, you tend to know what's wrong with it. You have to be very blind or uninterested not to know what's wrong. And once you know what's wrong, you want to do usually something about it because it's affecting your daily life. And that being so, you have to make provision to ensure that tenants have not just a voice, because we know voices can be, as you've just been described today, can be silenced or can be circumvented or can be marginalized. So talking about listening won't be enough. They have to be rather like the mindset. You have to change the mindset, which becomes embedded in the approach. You have to change the role of tenants such that they play a role in decision and policy making. Oh, some people might find that abhorrent or might find it's not the right place. We say quite the opposite. Interestingly, that the MMA does include a role to be played. We say they were right about that, but they just didn't implement it. So it's not a case just of having a rule. You have to make sure that the mindset allows the people who are in charge to ensure that where there is a role to be played, and we say there is, in decision making as well as listening, because the people are not only living there, but as you will see when we just deal with a little bit of detail, Mr. Shah's case, and I say it once, what I say in relation to him, he would want it known, and it was known. What he was doing was on behalf of all the residents, not just the leaseholders. He went out of his way to ensure that many of the major requests, observations that he were making were signed by residents in the tower. And the document I'll come to in a moment is a document at the start of this period, 2010, year after. And there's another one that comes right at the end in 2017. Both of them, as it were, bookends for this whole period, written by the GTLA, exposing the difficulties, but they're not just complaints. And I appreciate topic one is complaints. And I would ask that in a sense, that tenants and residents and occupants are not synonymized with complaints, because that is what RBKC and others tend to do. In other words, they're not treated as people who would have a view about whether it's a technical matter or not. Well, of course, if they're not given the information, they're certainly not going to be able to give a view, which, of course, is the human rights aspect of Mr. Friedman's submissions to you. So, therefore, we say, when you begin to look at what the detail of what residents were saying, this wasn't just about the colour of the wallpaper, if there was any, nor was it about just about the signage on the stairs. These were people who were thinking about how to make their environment habitable for themselves and, of course, anyone else who should visit or anyone else who happens to move in. So it's about a community and about construction and about positive ideas. It isn't about negativity. And of course that concept, that way in which they're characterized as negative, a negative influence, has to change. And it can only change, we say, if in fact they are given an embedded role to play, and they cannot be ignored, and they have access to information, and they have access to decisions, and they can make a difference. So we say those are important 4 points we'd make at the start. Just before I move to some of the detail, as a background to this, we say that all of this, that's the question of mindset, the question of approach, is political. In other words, one has to look back at the period, and I opened it in my very first opening to you, my second opening to you, and now in this closing. It's going to come up in the next module, which starts after we've been speaking, although not immediately. And that is, of course, that mindset, and I adopt what's been said this morning, comes from the top. And we all know who was on the top during this period that we're dealing with. And it was, of course, a government led by David Cameron. And he made very specific suggestions about health and safety and killing it off. If you set that agenda, if you set that mental environment, it's hardly surprising that further down, either consciously or unconsciously, the mindset sets in, oh well, health and safety, it gets in the way. We don't want a risk-averse society. Let's just take the risk and make the money. So in order to overcome that, and we would sincerely hope that questions should be put to David Cameron right here about that, because it is causative of a mindset. The mindset then has a knock-on effect to how residents were treated. Now, before actually dealing with the 2010 example, there are just a couple of other observations as a kind of preface, which originally was going to be in the written opening, but there wasn't enough space. Prior to examining some of the detail, there are some overriding precautionary observations which are crystallized throughout modules, all the modules, in fact, in phase 2, principally. Legislation, regulation, rules, guidance, advice is only as good as those who wield the authority. It's redolent of what I've just been saying. At all levels. In other words, despite the framework that pertained relating to Grenfell Tower and its maintenance, however deficient it was at the time, the disaster was brought about by those who cared not, and still don't, to those who thought lies were their business and laughed. Witnesses who, without exception, refused to testify before you and the families without an undertaking. This was the whole point of the families' questions that Team 2 repeatedly requested to be put to at the end of a witness's testimony, and it may have been wondered why this was so. And I pause for a minute, because if you were, and I'm not going to name this person because I think he will be familiar. He lost 6 members of his family, and he's one of the people, he's not the only one, who felt it important that here in this inquiry, which is not just about bricks and mortar, but is about families and what they were struggling against, that this was going to provide an opportunity for the witnesses who wouldn't come otherwise to answer questions without the undertaking of the kind that, what would you have done differently? Or what should have been done differently? Is there anything you wish to add to your evidence? Is there anything you'd like to say to the families? Now, of course, at one point one might think, well, we're not here really to ask witnesses those questions, but in our submission, it's a relevant question because you're trying to assess whether a mindset has changed. A mindset begins to change when the people responsible, through the RRO, the joint authority, have the courage to come here and say something along the lines, yes, you're right, we should have done this, we should have done that, and I'm sorry that I didn't. And look at the families sitting here and look them in the eye, and that's what they wanted. Because only then do you begin to see things have changed. That's the importance, we say, of questions of this kind. And you can look back on this inquiry, and on the occasions when the questions were put of a kind, how many witnesses in this module, or any other, the previous two, how many witnesses had that courage, had that responsibility to admit the responsibility and to apologise? We say you can count them on the fingers of one hand. And in the view of the undertaking that has been given to them, the families find that quite shocking. And it may be, we say, an interesting way of measuring where one is going with regard to this aspect. And in a way, what the families have been doing before this inquiry, and in order to illustrate the centrality of tenants, was told in a film that was shown in September. I think the panel was made aware of it, Grenfell, The Untold Story. Now, what is important about that film is you see for yourselves in a contemporary film exactly what it was that was going on. Because although it was commissioned by RBKC, no doubt in the hope that it might manifest a rather different complexion, but it didn't. Because what it showed, and some of the people in the film, I'm afraid, died in the fire, was them having to remonstrate with Peter Madison. The Victoria Borwick, the local MP, came to, as it were, mediate between the two. But you could see the frustration, you could see the irritation. They were raising not minor matters at all. They were raising window frames that didn't fit. You could stick your arm, well, they're exaggerating, stick your arm through the gap. But you heard in phase one about gaps in windows and so on. They were raising all sorts of issues that were important like that. And they were getting, and you watch the film, you see the reaction, implacable. There's a resistance. The body language is there. RBKC didn't really want to know. They were engaging for the purposes of a PR film. And by the end of it, of course, it was clear that intention hadn't been achieved. However, one of the aspects of the film which is important is that it was introduced and almost framed by a small boy. Again, I'm going to avoid names, but the aunt of this young boy gave evidence in phase one. He died. He's one of 17 children who did die because their vulnerabilities, it's a protective characteristic, of course. And children often don't get the attention that they deserve in a health and safety context, never mind in others. I won't repeat it here, but in our written submissions, we have devoted quite a lot of time to the provisions, both in terms of the international provisions and conventions that cover the rights of the child, which have been implemented in domestic legislation. So it's interesting that that film shows the struggle, in a sense, through the child talking about his experiences of the tower and drawing it in crayons on a wall. And then the adults attempting to get matters changed. Film was 2015, so it's during the refurbishment period. So that's enough, in a sense, on introductory matters. What I would like to do, so that you have an idea of the scheme, and I will endeavour to, I will do it by 1 o'clock, but basically the bookends are the 2010 fire and a letter that was written then. It's been mentioned before, but its detail has not really been, well, I can't presume that you haven't read it at some point, but it's easy to forget amongst the thousands of documents here. And I would start with that particular letter, and I have alerted those who are going to put the sections up so you can see it on screen rather than not. But I'll come to that in just one moment. But before I do, may I say we welcome what appears to be RBKC's acknowledgement about this matter. That is the 2010 fire and the 2010 letter. And this is what how it reads at the moment. It's very short. I'll just read it out because it vindicates everything that we've been saying, that Mr. Shah Ahmed more particularly has been saying, but it's taken all this time before a recognition that this fire and what he had to say, not just about the fire, but other matters, have an important part. So they go on to say that in relation to Shah's 2010 letter, the response from Anthony Parks understated the seriousness of the problems. I pause there. Understated? Misled. It was a misrepresentation. With the smoke control system, the result was that an opportunity to learn from those who experienced the April 2010 fire was missed. I pause. We welcome this, and one doesn't want to be mealy-mouthed about it. Obviously, we do welcome that. However, the bigger question is, why was it missed? Why was it missed? It was written out in black and white and referred to more than once. The attitude of KCTMO was virtually to deny the fire even existed. And we'll come to a moment in Mr. Black's evidence. If I just pause for a moment, I'll interpose it now. You may not have noticed, it's easy to overlook it, but when he first entered the witness box, he said something particularly and singularly appropriate. He'd obviously looked carefully, by this stage, at what he'd already said. And what he'd already said was, effectively, that there had not been any complaints about fire safety in his statement. Entirely wrong. And the letter's one of them. There were many more than that. But much more important, he'd omitted any reference in any of his written statements to the 2010 fire. They missed the fire? I don't think so. It's, again, illustrative of an attitude that just writes it off. Oh, it's minor, it doesn't matter, bit of smoke here and there. And one doesn't want to exaggerate it, but that does appear to be the situation. Otherwise, how do you miss something like this? You miss it because you're really not that interested, and maybe that's what the concession is making. The GTLA, I carry on with the recognition, had been set up because Leaseholders had lost confidence in the TMO. Black accepted in oral evidence that the TMO's response to the April 2010 fire gave GTL members further reason to lose trust in the TMO. Now, we are very grateful for that, but there's more to it than that. And the more to it, may I just begin the process? I'll try and speed it up, so otherwise it will take too long. Could we have on screen, please, the first page of the letter that was sent in relation to this fire, which had happened in April 2010. It was sent in September 2010, and I'll give the reference, which I hope the operator has. It's TMO 10037439_001. Ah, yes. Thank you. Now, if I'm running out of time, I'll just cut it short. But basically, you will see here, this is 2010. Patience had run out by this time, the time of this letter, never mind the response to this letter, which was, I put it bluntly, dishonest. Not by Mr. Black as it happened, but by Mr. Parks. And he was asked about this. But one will see straight away that what's happened is that a perfectly legitimate organisation with perfectly responsible people had decided that the only way they could get their message across is to write to the key people. Anthony Parks, the Director of Finance, and so on. You can see the names there. I don't read them all out. So, and then it goes into some points here which are important because of another document. We received a written response dated the 20th of August 2010 from Daniel Wood, from the head of home ownership. However, we were expecting a direct response, either from you, that's Mr. Black, who'd been appointed in 2009, for the simple fact you, Mr. Black, originally made the commitment to look into our issues and concerns. In fact, he hadn't. Mr. Wood, in effect, refuted and flatly ignored our long-suffering and serious issues. So this is before 2010, obviously, and 2009, for that matter. This demonstrates, as head of home ownership, he's not aware of the reality of the situation at Grenfell Tower, and he's out of touch as to what's going on. It seems he's based his response on what appears to be common answers. If we simply take the issue of block aesthetics, it's clear to see how Grenfell Tower has been neglected for decades. The letter we received indicates the TMO does not adhere to its promise of being a tenant-led organisation. And then he goes on to deal with other matters. May I pause there and ask if we can have on screen something that is extremely important in the light of that, what he was saying. Could we have, in fact, it's been mentioned in passing many times and again this morning, but the Mamoli report, please, or at least not the whole of it, it's the recommendations, which I think should be IWS 401462/43, and it's attached to Shah Ahmed's statement, in fact. We have the recommendations, please. That may be that's... I can deal with it without it going on screen.
Well, it might just take a moment or two.
I'm only going to put on screen those documents that we feel do need to be underscored somewhat. Well, may I proceed so as not to waste any time? What I will do is indicate what I'm reading from, which is only the recommendations section of the Mamoli report, which is on the page I've indicated, but it may be difficult to find. We did provide these in advance, but I understand the difficulties. So in the recommendations section, there are a number of headings. So I'm not going to read the whole of it, it'll take too long, but there are important observations. This is being said in 2009, April, the time that Mr. Black is appointed as the CEO. We mention it because hardly anybody admitted knowing much about it, including Mr. Black and the leader of the council. They'd sort of heard of it or seen it, but they hadn't read it. Or they've been encouraged to, as has been pointed out today, to really downplay it. No wonder it wasn't accepted. No wonder it wasn't acted on, because it's counter to the culture of the RBKC TMO. That's why. The culture we've already described. And this is what the first heading says: Customer Care, by Maria Mamoli's report. Customer Care, PR, Communication, Training and Development. First recommendation, the very first one: for there to be a process of mediation conciliation to build relationships with aggrieved residents and the TMO. Relationships between certain factions of the residents and the TMO have broken down irretrievably. Only an independent process can intervene to try and improve relations. That's how bad it was in 2009-10. And it was highlighted. And it was highlighted to the effect that there should be an independent element in the retrieval of the situation. And quite rightly, because we would interpret here an understanding by Mamoli herself that she could not leave it to the TMO or the RBKC to improve relations. And when you watch what's happened since, she was right. Her second recommendation: a customer care training programme, especially for frontline staff, whether full-time, part-time or temporary. All the staff at TMO should greet and meet residents with the utmost respect and courtesy, and always show willing to assist residents in their inquiries and be prepared to take on responsibility for acting on those inquiries. I hope that doesn't encourage too many rather wry smiles when one reads that and then looks at what actually happened after 2009, 2010 and all the way through. That certainly it could not be said, and I'm not going to name particular witnesses from RBKC TMO, that there was undoubtedly an attitude of hostility towards the residents, and almost regarded as some sort of febrile fanaticism. They were demonized in that way. So it doesn't reflect this recommendation. Third recommendation: TMO staff appraisals to reinforce customer care and respect for residents and their roles and responsibility both within the organisation and towards residents. Fourth, a re-examination of the core principles of the TMO. Conduct a skills audit of staff to ensure they have core competency. I'm missing out some of it. And that there's a full complement of permanent, full-time or part-time skilled staff for continuity and to make use of the long-term consultants. In short, an investment in people. I mean, this, we say, is absolutely spot on. She's hit the nail on every single occasion. And I'll summarise the remaining ones on this page. A more proactive approach to be taken by staff and their contractors to share information. My goodness. That is a situation which I think Mr. Ahmed and others, and Eddie Dufan, were seeking information so they can know. Throughout the whole of this period, Mr. Ahmed didn't know about the FRAs. They weren't shared with him. He didn't know about Mr. Stokes. Why didn't they share it? Well, one has a ready answer in the case of Mr. Stokes. They probably weren't too keen for him to be examined closely. So you have and I haven't finished. I'm just saying those are just the first 7 recommendations. But there's a heading dealing with the complaints procedures and how that should be rectified, governance and oversight, particularly oversight of performance. It's already been referred to, but also just one final reference to a heading which is important, and that is major works and repairs, which of course occurred after this report. The Council, as freeholder, to take more of a proactive role in the monitoring of major works, contracts and cyclical repairs, and to be robust in checking the TMO's performance under the MMA 2006. Couldn't be clearer. Who's listening? we say it's certainly not RBKC or TMO. That's why we say this was parked, this report. Rather like the film they commissioned, they probably didn't like the result. Rather like this report that they commissioned, they didn't like the result. And so like the residents, it was essentially ignored and put into. There were all sorts of robust monitoring suggestions, tightening up procedure, regular structural surveys. You read through it, it is an indictment in itself of why this letter, starting as it did, if we could kindly go back, I'm sorry to dart back and forth a bit, but to go back to the letter itself, TMO 100, oh, thank you very much. There it is. That's why the beginning of this letter is the tip of an iceberg, because, as Shah Ahmed said, he was aware of the Mamoli report himself, even if Mr. Black and the deputy leader of the council, Fielding Mellon, didn't know or didn't take it on board. So may I then ask to go to the next page, which should be, well, underscored, yes, heating, yes, right at the top. So this is the second page of this letter. So I'm not going to go through the many headings here, and they're not, they can't be categorized as complaints. They can be categorized as participatory and informed, as far as they were, issues to do with tenants as a whole, not just the leaseholders. Anyway, at the top. Secondly, we will argue that the recent fire at Grenfell Tower has raised so many health and safety issues with the building that it demands an independent investigation and inquiry into the safety of the building. I'll read the rest of this, so safe, keep going back to the page. We'll raise points about the school I don't trouble you with. We are fully committed to resolve every issue we raised in our letter dated the 28th of July. Again, that's available should you wish to see it, amicably. So these aren't febrile revolutionaries of any kind. These are concerned citizens, because it is to do with our homes, well-beings, health, safety, and above all, of course, unnecessary financial hardship which may be imposed particularly on leaseholders. Now I pause because the one at the top is important, independent investigation. Now why we say this is important for a number of reasons. And it may be at the time Mr. Ahmed hadn't really necessarily thought all of them through, but he does come back to them later. But the central point is, because he was unaware of what was going on within the council and the FRAs and the assessor himself, he quite rightly was saying, we want an independent investigation. Had there been, and this is why we say we might not have been sitting here if the council had listened to this and acted on it. Of course, they never in a month of Sundays were going to do it, because they were protecting what was already in place, which was unsuitable and insufficient. We say that had there been an independent investigation, perhaps I don't need to, with the time constraints, rehearse all the comments that have been made about Mr. Stokes, reckless, and the extent to which he endangered particularly those with protected characteristics. One only has to think back to his giving evidence and the very careful examination by Mr. Millett of him and his nominals. And Brian Stokes and Associates. What associates? He hasn't got any. One is tempted to say a sham from start to finish. He hasn't got any associates. He's not peer reviewed. And I know the families are very anxious that in the future, fire risk assessors are so central to what is happening that they must be, and it's already been said, so I'll say it very quickly, they have to be qualified, they have to be experienced. And if they haven't got the experience that is needed, then they better get it, or ask for advisors to come in. So, for example, when Mr. Stokes eventually was asked about the cladding, instead of finding, just asking a question third hand, he might be capable of looking at the outside of a building, Because, as you said yourself at one point, it doesn't need the the RRO to come to this conclusion. If you're a fire risk assessor, what do you think you've got to assess? Well, you've got to assess possible sources of a fire. And you say, well, I'll look at the whole building, but I won't look at the outside. Seems a bit odd, doesn't sound very commonsensical. Never mind the rules for the moment. We say the rules did include the facade. However, we're not going to spend scholastic time on a pinhead to work out that it would be necessary to look at sources. And sources of a fire, and then spread of a fire, and then how you escape from a fire. You put it very simply, that's it. That's what they've got to do. And it's absolutely vital that you get the proper advice about all of these stages, which you so succinctly summarised as the job of a fire risk assessor. And in fact, if we'll see in this letter, what was happening was that Shah Ahmed had become the fire risk assessor as best he could be, suggesting things that had to change. And he was performing the role of supervision, scrutiny, because it wasn't happening within RBKC. And he had a particular motive, of course. He's a leaseholder. He's responsible to them for money being spent on matters related to the tower itself, whether it be safety or not. So he was doing this role himself, essentially, but he wasn't alone, because, as I've said, he was acting on behalf of others in the tower, nearly all the people in the tower in the end, and even that was belittled. Oh, well, somehow or another, there was a suggestion that he and Mr. Defan had pressured people into signing these petitions? No, it's the same story all along. That if you come up with a petition, well, it's not a legitimate one. If you come up with an idea, well, it's him, he's on about that again. One of Mr. Black's asides. Is it that old stuff again? So what one sees, that mindset is the theme that runs through the whole of this. But there's another reason why this particular sentence is important. And I hope it doesn't stray too far, because you see this letter is broad in its remit itself. It's not just about the door handle, let alone the closes. Because this deals with inspections. Appreciate you've been dealing with module 5, and there's other modules to come, and we've put it in written submissions. It comes at the end. We've put reflections on principled priorities, we call it. So we haven't framed them as a recommendation, although there will be, before the end, we will try and put into one document recommendations throughout. But I raise it now because it links to this. If there had been an authorised independent inspectorate of fire safety, then it would have, hopefully, it's another, as it were, safeguard, been detected if there'd been an inspection of the building, independent of the fire brigade, independent of the council. And that is, in fact, just briefly looking at the building safety legislation that is going through at the moment. Inspectors of the built environment are now countenanced, and we would welcome that, and we would welcome you and your colleagues' observations on how the inspectorate should work, because we think that Shah Ahmed, in this one paragraph, put his finger exactly on what was needed. And this is not the only time he raises it. I'm not going to mention all the other times. We'll come to one other time in a moment, the letter that comes at the end of this period. So, inspectorate. Then could we turn to the next page, which is 3, safety, security and reception services. Now, it has, again, repercussions for now and the future. He's talking about security guards for a number of reasons, and they're not doing their job. But the second paragraph, the incident of the fire at Grenfell Tower, is a perfect example of how security guards are inept at fulfilling their duty. When the fire alarm was ringing in the reception area, which is one of the few areas where it was, and the lift was automatically out of service, the security guard was unaware of what was happening. She didn't advise people to avoid using the staircase and didn't take control of the situation. We're confident that if you were able to review CCTV footage of the event, you would be able to note the fact that she actually opens the door to provide access to the staircase for a resident of the building to use the staircase to reach his flat. This is despite the fact staircases were filled with smoke, but she was oblivious to this fact. So one can imagine the seriousness of the situation. She put individuals' life in danger, and this resembles serious negligence by incompetent security staff, and the TMO has to bear the responsibility. Your eye might be caught just in the next paragraph. There's a sentence: a patrol log should be written noting any such behaviour, that's antisocial behaviour, and safety issues, such as flooring, dry risers. Now, dry risers is a point that you will recall. It was blocked between 2013 and 2014. So again, he had a point. He didn't know that, but that's being blocked, or any general maintenance work. So I pause there on this page because the significance of this is it's again in our principled priorities. It's again a sort of theme that he, Mr. Ahmed, and others have brought up. And it relates to PEEPs as well. So may I extrapolate as to what the essence of this is? It is, in fact, where you have a high-rise block, where you have difficulties with people in the block who are not going to be able to, as it were, evacuate very quickly or at all by themselves, are going to need help. Who's going to help them? And we say, of course, there were misleading statements saying, oh, we'll evacuate the block. That wasn't true. They weren't going to be able to do that. The only way you can begin to think about the possibility of, as it were, affording safety to the tenants and the occupants is that there is somebody, a concierge, who is on duty, not just ticking off and falling asleep, but someone who's actually qualified in fire safety. So as he's got here, patrols the building. These are constructive suggestions that residents were making. Patrol the building, yes, absolutely. And not just see whether there's a bit of litter on the floor, or worse, but actually, are things working? They have to be trained to do this, of course. But then you begin to get practical answers to and that's why the residents, and I'm using the prism of the residents to illustrate the things that have to be done. This is one person's narrative of reflecting the thoughts of many others who live in the tower. So a concierge would be in a position to supplement and implement safety in future, particularly with regard to the vulnerable, but also with regard to safety. All we had from witnesses, well, if I happen to notice something, I might do something about it. No, there has to be a fire safety strategy, of which there wasn't one. And no doubt, had there been an independent investigation, they might have actually uncovered that there wasn't a strategy in place, a holistic strategy, an integrated strategy, part of which, of course, is repairs, door closers, and all the rest of it. It is also ensuring that you've made provision on the ground with somebody who's able to assist. So I think probably the point is made as clearly as possible. Now, could I ask now for the next page? The next page has two headings of importance. Yes, consultation and summary of costs. Consultations is another issue. Again, these are all paragraphs that have not been read out before. As we mentioned in our earlier letter, we must be consulted in detail in relation to any major work. And he cites, rightly, the 1985 Landlord and Tenant Act. and Commonhold and Leasehold Reform Act 2002, Section 153, and so on. That's to do with service charges. We need to be notified, and so on, because that's linked to cost. But he was on to a much bigger issue, of course, the issue of consultation, of which you've heard a great deal and of which we say should be central, not just decision-making or listening, but actual consultation. And if I may just elaborate a little more, because Mr. Friedman has already touched on it, but it couldn't get worse than this. And it links to the MMA. It contained provisions, this modular agreement, and which is why we say you've got to have the right people as well as the right provisions, contained provisions which, if implemented, would have ensured that the residents were at the heart of decision-making during the refurbishment, including establishing a client review group chaired by a representative of the Residents Association to act as the client for the project. Just imagine for a moment, the client of the project, rather than the one that they had. And a representation of residents on the project team, involvement in the appointment of consultants, exactly a point that Mr. Abed was making, and others about the appointment of architects and so on, including architects, representation at site meetings. KCTMO completely ignored these obligations, and although it's now admitted, it's difficult to really excuse it, because these were obvious obligations mentioned in Memoli. So we say flagrant omissions by RBKC. And when Mr. Madison took over responsibility for the project, he's fully aware that there had been a failure to engage residents. And his wordings were inadequate and intermittent communication has also given residents cause for distrust, and they've resorted to making FOI requests to obtain information, just imagine. They believe has been denied them. Well, they were right, had been denied them. Not believe, they were right, had been denied. The TMO chose not to have public meetings, giving excuses about some people who spoke rather more loudly than others, primarily relying on newsletters to update residents on progress. These were actively misleading. Zinc was consistently identified as the cladding material, and residents were never told that ACM was to be used. So again, it's the point you've heard this morning. It is about non-disclosure, it is about non-transparency, and essentially the human right. If you're going to protect a human right, you need the information. These were actively misleading statements. I don't need to perhaps go further, except to also mention HIUs, the units that were, residents were misled about where they were going to be, they weren't consulted. That's also in the film Untold Story of Grenfell. So, therefore, that paragraph is extremely important. We then come to a long paragraph, and perhaps given the time, I won't read all of it, but I think there's 3 paragraphs here that are acutely important back in 2010. As we mentioned in our previous letter, prior to 2005, the suffering of the residents due to lift malfunctioning was caused by inadequate services and maintenance provided by the TMO. We agree 100% it was right to replace the lifts when their useful life came to an end. What we're unhappy about is your choice of contractor, which was hired to carry out the work. Every resident is aware of the fact it took about 1.5 years to replace the 2 lifts, and so on. And he goes on about poor management in relation to installation as well as maintenance. We are also shocked to hear that your lift engineers have told you that the response time for lift repairs is normally 2 hours and 4 hours out of normal hours. This is simply not the case. We've experienced a lift being out of service for a week, far more than your suggested 2 or 4 hours. And he talks about being trapped, other people being trapped in the lift. Now, lift is a perennial theme. You've heard it many times. All the way through 2009, all the way through, even after refurbishment. Because when the fire brigade come, as Stephanie Barwise indicated, possibly because they got the wrong key, lifts were always a problem. What was at the heart of the lifts situation? Well, I think it was Mr. Stokes was partly. he didn't know what a firefighting lift was. This comes from Mr. Todd himself. And Mr. Todd went on, in a sense, using your invitation to be frank about it, he still doesn't know. He still doesn't know. And then one wonders why he gets classed as dangerous. Because in a building of this height, there has to be a compliant firefighting evacuation lift, because it's one of the many, as it were, systems that make a package of safety. And yet, 2017 still hadn't got there. So you see that when he raised this issue, and could we turn over the page quickly, because at the top of the next page, right at the top of that page, the new lift paragraph. The new lift was installed about 5 years ago, resulting in hefty bills for leaseholders. But if you look at the condition of the lift now, they look as though they've been used for over 20 years. Dire need of maintenance. Half the buttons no longer light up. The inside of the lift is scratched in several places. The doors of one lift take a lot longer to close than the other. This is all due to poor maintenance and misuse. I mean, this is the refrain. Maintenance, maintenance, maintenance. Because there was no system. No proper system of follow-ups and so on. And of course, an inspection might have revealed that. Might also have revealed the backlog, huge backlog of repairs and FRAs that hadn't been actioned. Why? Because there wasn't a system. And all that Mr. Stokes does goes along and asks and doesn't follow it up. No follow-ups, nothing. So again, this doesn't require legislation, or it shouldn't. One would imagine that if you're doing a job in which you're saying X is wrong, next time you go, you want to find out whether X is right. And if it isn't right, why isn't it right? But this kind of approach to fire and safety doesn't seem to have percolated through. Now, may I just turn quickly, there's common parts electricity is the... Yeah, common parts electricity. This is important as well because it's another factor which he's lighted upon. And this is very important, what he constructs. It's very constructive proposals. It is understandable that areas that are not naturally lit will need lighting, such as the fire escape and chute room. Is it not conceivable and reasonable idea to put in motion sensor lighting in the chute rooms and in the in-between landings of the fire escape stairwell? That way, the chute room light will only come on once it is in use. Then 20 or so floors will have lighting 24 hours a day throughout on their stairwell, with the in-between floors being lit only when in use. This would not only help the leaseholders financially, but also environmentally friendly. Well, he's right about the lighting, because when the report eventually came, 2014, you will recall, 25% of the luminaries, as they were called, or luminaires, didn't work. So he's, again, put his finger, it's lifts and so on. And of course, we get to the key passage at the bottom of this page, fire alarm and health. And I'm going to just read some of this because it's right at the bottom. Thank you very much. Fire alarm and health and safety. We're very shocked to learn from you that you considered the defects in the building exposed by the fire as a minor fault, when it had potentially fatal consequences. The minor fault caused so much damage to individuals living in Grenfell Town, it's difficult to imagine how serious an event has to be for you to consider it a major fault. If the fire alarm system is not functioning and the vents are not working, then it should be considered, no doubt, as a major fault. They are used as measures to save lives. So if they're not working, then obviously you're endangering the lives of the residents. Well, he's right. That's why we say from 2009 onwards. It was not safe, not a safe building. And he goes on to deal, but before I leave this page, may I just reflect on one thing he's already said, but in the context of lighting. I say it now because of trying to bring forward matters that we put later. You'll see reference to the chute in the common parts electricity section before we turn over the page. In the middle of that paragraph, lighting in the chute rooms. Now, I don't know, and it's none of our business, whether you have all had an opportunity to go up the tower. And we hope that at some stage you have managed to do that. And I'm going to insert this because what struck some of us, and this is in a sense, giving evidence, but others have seen it. When you went up the tower, there were interesting spaces on every floor which had been untouched by fire. They were the shoot rooms. And why were the shoot rooms protected? Because they had a metal door. There was only one where the door had been left open, where the fire had got in. And we say, although that wasn't the purpose of him putting shoot rooms in there, he may not have thought about it. But one of the principal priorities we want considering here is, if we appreciate in new buildings, there are areas called safe havens, which are another, if you like, protective measure, particularly in commercial buildings. Well, why not residential buildings as well? Safe havens. So if you are stuck on an upper floor, it may be the only chance of survival is not a shoot room as such, but a safe haven of the kind that could have been adapted here. It needs a little bit of imagination and a little bit of provision in order to do that. So I mention it because it was a feature of the tower when everybody went up. One assumes the doors are still there. However, moving back to this letter, over the page, I'm on page 6 now at the top. We are certain that out of 120 families living in the block, no one is aware of the evacuation procedure. We have never had an evacuation procedure booklet sent to us for the past 36 years. And we say stunning that it's quite as bad as this. Is it not necessary by law to test the fire alarm and associated equipment on a regular basis to check whether the system is fully functional? And then he talks about many people couldn't hear the alarm that did go off and they weren't aware of the fire. And then a passage which I have read before, but I just, that was in opening, I ask you to mark it up. As you know, fire does not kill as much as the effects of smoke and the devastating consequences. And to our knowledge, some of the residents nearly died, this is the April fire, due to smoke inhalation and suffocation. On top of this, many residents found the whole experience traumatic and mentally damaging. And then he compares what Hammersmith had done. So again, he has, on behalf of residents and other residents, put his finger exactly on what the problem was. And this is in the absence of cladding. This was a fire that had nothing to do with cladding. This was a fire to do with, I think it was rubbish on a higher floor, which spread above that, internally, irrespective of compartmentation. So it was a situation they should have been looking into, but they were regarding as a minor event. And he notices immediately after the fire that they installed a new fire alarm system. So, but we say that doesn't make very much difference because you have to look at a whole system in an integrated form. If you're going to have a smoke detector or alarm that sets off a vent that then sets off, as it were, extraction, then they're all interrelated. There have to be regular checks of the alarms, of the lifts, of the keys to make sure they work. And he finishes this section by saying, essentially, the residents of Grenfell Tower have been treated as subhuman, and your handling of the incident has been unacceptable. And we say that this is not an exaggeration, this is not hyperbole. This is exactly what Maria Mamoli had been talking about had not changed. And as you go through the whole period, and I'm going to do it, if I may, rather quickly at this stage. After the Inferno, you have a number of, I just list them because you're very familiar, and I don't I want to overburden you with things you've heard so many times. 2013, Lacanal inquest, 4 months, recommendations, March the 28th, sent to councils. So that's a key event. The same time, well, not quite the same time, about a month or so later, in the same year, it fortunately wasn't another fire, but it was in the tower, and it affected a number of residents. Again, denied to begin with. They had to take them to court as far as the fire in 2010 was concerned in order to get liability admitted. That's why the 2010 is important. And it was still being basically denied, the 2010 fire, when we get to 2017. But in 2013, from the 11th to the 29th of May, various electrical equipment exploded. We're not dealing, as I may have put in another context, we're not dealing with toasters, we're not dealing with kettles, we're dealing with computers and electrical equipment of some importance. And again, the residents, including Mr. Defan as well, had to persuade the authority that this was serious matter. And in the end, the authority had withheld information that they had. They had an electrical fault report in 2013, which indicated essentially that there were covers missing to the Paxoline covers. In other words, with the Ryfield boards, which deal with surge arresting for floors 11, 12, 13, 14, 15, all the floors up to 18. So they were in a very bad condition. That means nobody was bothering to look at that, let alone Mr. Stokes. So therefore, 2013, they get a report from Lacanau, they get the surges report, so they must know about it. And in July of that year, we're still in 2013, they get the already referred to, the Hodgson safety report with 39 issues listed. 2014, they get a deficiency notice, as you've heard, the March one, which has the 25% of vents not working, 25% of lighting not working. And then, in November 2014, Claire Williams has her Lacanau moment. We all wish some others had had Lacanau moments. It might have shed light on something that things were going on. In 2015, there's a deficiency notice. I know the families are particularly anxious about the Adair Court example, the Adair House example on Adair Tower, and its sister building, Hazelwood. There actually was a fire in Adair Tower. Closes are right at the centre of it. Evacuation is quite at the centre of it. So the deficiency notices and the enforcement notices are served on both authorities jointly. So they have to know. What are they saying? Oh, well, it's not exactly the same as our tower or Grenfell Tower or whatever. So that's in 2015. 2016, just round the corner, Shepherd's Court. And Mr. Ahmed actually happened to see that. He was there or nearby. And that leads into, really, essentially, I've gone through those because it was in 2016, there was the deficiency notice served on Grenfell Tower with a return date of the 18th of May 2017. On the 20th of November was the playing with fire blog you've heard about. So the signposts are dramatic and there. And therefore, in the closing moments just before lunch, may I just turn to really the other bookend? I haven't got time in this context to go through it all, which may be a relief. I will just give the reference to it and ask you in the fullness of time to have a look at it. This is a letter that was sent, and it's contained in his statement, Mr. Ahmed's statement. The letter was sent on the 21st of April 2017, just prior to the fire. And it was a letter like the first letter, only this one was sent to Laura Johnson and Sasha Jevons. And it was dealing with the fact, and I'm not going to bring it up in these moments, but what they were essentially saying was, how would you like to live in a flat with this sort of pipe going through it? And then there was a photograph of the pipe. And they were saying, it's not just artistic. It's not just that it's not something you want to live with. We're actually worried about safety. We're worried about safety and interim protections. I don't think at any stage, because there wasn't a fire safety strategy, that the council ever thought, that the TMO ever thought about interim measures while you haven't got vents that work, while you haven't got a fire safety lift, while essentially you're inserting gas pipes and you're putting them up, essentially the shaft for the fire brigade to use. Shouldn't have been really put there. Preferably, as you may remember, we would have liked to put the pipes outside, but we couldn't. Why? Because we were worried about the cladding. Well, it gives you a sense of the priorities here. Aesthetics before safety. There are ways of putting pipes on the outside of buildings which would have been safer. In fact, they were right. And this letter, which goes through in some detail, again asking for an independent investigation, not just of the pipes. Is it right that they're being put in unprotected? Is it right to keep the gas on while they're unprotected? There's no corrosive protection, another of the experts. No corrosive protection. So here you have these pipes going up the main shaft, going into flats, possibly breaking into compartmentation. And what he's actually doing in this letter as well is he's saying, oh, by the way, cladding. Interesting. He's raising cladding. Not for the reasons that he realised, but because he and others at the top of the building thought there was some peculiarity, a noise that couldn't be located. Interestingly, of course, had there been an inspection, bearing in mind all the things he said, please look at, cladding might, even at that very late stage, have been isolated as a possible route to a fire. Given that our contention is that cladding was something to be looked at in any event by the fire assessor, this was an important point. But even perhaps more important, and I'll read this out without getting it up on screen, what they say in this letter is also, not only do we want an independent investigation and certification, the defence apparently to this is, oh, well, we did take that on board and we're very grateful for another acknowledgement, this time from the TMO, acknowledging the concerns relating to the gas riser raised by the residents, including the Grenfell Leaseholders Association, with a request for an appointment of an independent health and safety advisor to consider the works in relation to the concerns raised. TMO passed these on to the contractor. No, wait a minute. It's not about passing it on to somebody else. That's what they do all the time. What they should have been doing, and your experts indicated, that GTLA and others were quite right, because it was their action of pointing it out to the TMO and RBKC that this was an unsafe exercise that caused them to do something about it, although they should have done something about it before they started inserting these pipes, because there'd been a gas leak in September 2013 and they had to switch the gas off. And you wonder why, in the end, the frustration of not being taken seriously, of not being listened to. What did he have to do? What did the GTLA have to do? What did he have to do in person, as well as Mr. Tafana and well as others in the film? He had to put all this together in a dossier. He had to employ a lawyer, just as he had to in relation to 2010, to fight the council over safety issues. And he had to take, because they didn't tell him what they got. He took the dossier and all the observations, I don't call them complaints, they're observations for the future, in the 2017 letter, as well as the one in 2010. He takes them to the council, but to ensure they don't get stuck in a complaints procedure where they might be escalated or de-escalated, he takes the dossier to the town hall. He's taking it right to the centre, because he knows unless he hands it in himself, somehow or another it may go missing, it may not get attended to or whatever. And he did that at the end of the month of May, just before the fire. So right up, as it were, to the doors of Grenfell Tower and the fire, the residents were having to fight a battle. And a section in the letter which there is time just to read to you, because this is astonishing. if you need any persuading that the RBKC-TMO were just not wanting to confront their shortcomings, it's this. It's a paragraph in the 2017 letter sent to Laura Johnson. They refer the letter to an email from Laura Johnson dated the 28th of March, in which she says about what they're saying about the 2010 fire. This is a serious allegation which I've reviewed with the KCTMO, and I can confirm that RBKC and the KCTMO do not, and I read it carefully, do not have any record or report of this. That's the fire, which they're now admitting, of course. And they did in a legal action. I don't know whether they had forgotten. We have no record of 3 people being injured. It's in the fire brigade report. And we have no report which links this to poor maintenance. And yes, they do. And finally, we have no record or letter from the fire brigade mentioning this or providing any formal notification, to which the letter writer, who happens to be Lee Chapman and Mr. Tunde Awudero, having to say they're going to take legal action as a result of that. So right up until 2017, the 2010 fire, the liability for the fire, in the sense of the smoke spread and so on that happened there, was still being resisted. That is why the acknowledgement by RBKC, well, I say today, but perhaps, well, yes, later today, it is welcome at long last that he can rest back on at least a rather late acknowledgement of the fact that all along, all through those years, and you can believe through his own passion, he wasn't able to give evidence, as you know, but the passion of the letters, the passion of the files and the dossiers that he's put together for your assistance, thousands of pages, he bothered to keep things so that even after the fire, he had some record of what had happened. This is how assiduous he, and others, he's not the only one. And so we say he's been vindicated. And that's why we say, in future, there should no longer be the Ahmeds of this world who have to fight every inch of the way to get any movement, to get any recognition, to bring about change. And I'd like to end with not his words, and I haven't named them in the written, but it may be you can guess who spoke them. It's not from a source you will necessarily recognise, but you might do. These are words, one of the few occasions when a reflective question was asked of this witness. It's a woman. She said, "I grew up in council housing, and I've seen its demise since the 1980s, when Right to Buy was brought in. There's been deregulation on the sector. There's a lack of investment going into council housing, and I hope that you will look at this in a wider context," addressed to the panel. Council housing is a really important community asset that should be valued. Those are the words of Amanda Johnson. So it might not have been appreciated or expected that somebody on the inside has recognised the point of what we've been trying to suggest to you, both in the written and the oral form. Thank you.
Well, thank you very much, Mr. Mansfield. And at that point, I think we'll break so that we can all have some lunch, and we'll resume at 2 o'clock when we're going to hear a closing statement from the TMO. Yes, thank you very much. 2 o'clock, please.